Check. Check, check.
Good morning. Welcome to this very special session of the Wyoming Supreme Court. I want to thank you all for being here and thank Casper College for hosting us. What we're going to do this morning is have a real Supreme Court oral argument, and then we will break briefly and have a mock oral argument, and we'll ask for participants to come act as members of the court. I think we'll have a brief question and answer session as well, so stick around. Thank you all for being here. Maybe I'll wait till these people are seated. The case you're going to hear arguments on is Monique Sullivan versus the state of Wyoming, S24-0063. We always live stream our Supreme Court arguments when we're at home in Cheyenne. Are we live streaming this one, Shauna? Are we live streaming? So if you think this is really interesting, you can come to Cheyenne anytime we have oral arguments and listen to those as well, or you can get on the Wyoming Judicial Branch website and listen to the arguments that you think might be interesting. So welcome, and we will start. Counsel.
Good morning, and may it please the court. Counsel. Your Honors, a picture is worth 1,000 words. This case arises out of a conviction for voluntary manslaughter from Lincoln County, in which the trial showed that my client, Ms. Sullivan, in her cabin on a wintry blizzard night on a ranch outside of Kemmerer, stabbed her fiance, and he ultimately died from those wounds. She was originally charged with second-degree murder. She claimed self-defense at the trial. The district court, with no objection from the prosecutor, gave the lesser-included instruction of voluntary manslaughter, which, as opposed to second-degree murder, which requires malice, requires that the crime be committed in heat of passion. The very first witness in this trial was the decedent's father, who was miles, in fact, continents away. Ms. Sullivan is from Australia. The decedent is from New Zealand. This is where his father lives. He was nowhere near the incident at the time, and the state called him as the first witness in the case and laid foundation for a picture of the decedent in his favorite place with a little dog that he had brought home to the family, which of course has absolutely no relevance to any of the elements of the crime alleged in this case. And Wilkes, the 2002 case, specifically prohibits in-life photos in homicide cases with the decedent. And I'd like to just quote briefly from Wilkes because I think it's very important. Photographs of homicide victims taken during life should be admitted to the jury only under very limited circumstances. They are inadmissible unless they are relevant to some material issue and their relevancy outweighs the danger of prejudice to the defendant. When there is no purpose in introducing such pictures into evidence, such admission invokes the sympathy of the jury and constitutes error. Admission of homicide victims in life photographs is discouraged and should be permitted only under very limited circumstances where their relevancy outweighs the potential to inflame the jury. There was no relevance to this photo. Now, the state gave multiple and conflicting justifications for submitting this photo. One, to show that he was alive when he was stabbed. That was clearly not an issue. One, to show, for the father to explain why Mr. Moore was in Lincoln County, which has no relevance to this matter. To establish his identity. Now, all of these things could be possibly somewhat relevant. Agreed. But here in Wilkes, we are cautioned, unless there is great relevancy, this has danger to invoke the sympathy of the jury, which is exactly what happened. The defense attorney objected, and the district court let it in.
Yes, I think that might be the key. Counsel, I think that might be the key issue. So let's just assume that we agree that it was irrelevant, should not have been admitted. Maybe you could go to the prejudice to your point, because it seems to me that that's your hurdle here.
Thank you, Justice Gray. And I agree. I think, as I said in the brief, that I don't think there should be a whole lot of dispute that this picture was admitted in error. And, there's so many cases where error occurs at the trial level. And so many times, those cases are not reversed because it's not prejudicial. Well, in the cases where, Wilkes was not reversed. Wilkes was in his home. He shot a Pizza Hut delivery driver. He admitted to it. Of course, there was no relevance there, and it wasn't prejudicial to introduce this photo. There's other cases, Havarina, the stolen Harley bicycle, motorcycle. There was no reason to admit that victim impact testimony there, and it wasn't prejudicial. It didn't matter. But this is a self-defense case. The decedent was 6'4", 225 pounds. His nickname was Kills. There was a lot of testimony in the case about this kind of being a bit of a boys' club. Miss Sullivan is stranded. She's millions of miles away. She doesn't really want to be there. She's not with her friends. They've been fighting all the time. There's drinking going on. There's one stab wound, not multiple. It happened with her friend in the room, why would you commit a murder or manslaughter with your friend in the room? So many factors went to self-defense in this case. And it's so much more prejudicial, especially as the first witness in the case, in a self-defense claim. If there was ever going to be prejudice, it would be in a case of self-defense. There's in the Justice case, which was the 1989 case, which first went to the prohibition against victim impact testimony. That was the aggravated robbery outside in a convenience store in Buffalo. The only question there was identity. If the only question in this case was identity, I agree, this wouldn't be prejudicial. In fact, if the only issue was identity, Ms. Sullivan would probably stand up and say, we feel so terrible what happened. Yes, this was a beautiful person. He was a great guy. We agree. It's horrible that he was killed. It just wasn't my client. But in a case where it's self-defense, and all of this stuff matters, and who's a mean person, who's a nice person, who's a violent person, who's a peaceful person, is so important in cases like this, and that's where it's so prejudicial. And I believe, again, I said this in the brief, you can't ever prove intent with direct evidence, hardly. I know that works against our clients all the time, circumstantial, but the prosecutor knew that. That's why he wanted to get this picture in the first thing in the case.
I don't disagree that philosophically in a self-defense case there was the potential for prejudice, but in this case you have some really difficult facts to get over, and I wonder, get us there, because you have your client admitting to law enforcement that she became enraged before the stabbing, and there's no statement from her to law enforcement at that time that she was acting in self-defense. That's pretty incriminating. So how do you get over that evidentiary hurdle on prejudice?
Thank you, Justice Ross. And I agree that that's what Ms. Sullivan said to law enforcement in the moments after this incident. Of course, she testified otherwise at trial under oath. And of course, at the trial, the defense attorney made the point, made the argument, knew that was a problem, and drew that out from Ms. Sullivan on her direct testimony and made the arguments. And in fact, in cross-examining the lead detective saying, okay, well, you know, this is complicated. This is her fiance. She loves him. She probably doesn't want to say, hey, he's an abuser. He's beating me up. She's ashamed. She's scared. She doesn't know who she can trust. She doesn't know what the consequences are. She's far from home. She's under the influence of drugs. She's just cut herself. She's receiving medical treatment. All these kinds of things are going on. And of course, you know, that was an issue that the state focused on that at the trial. But I think what that gets to is, you know, we're here kind of reweighing this evidence at the trial. And of course, the main factor in prejudice is the strength of the case. And of course, the state is always going to say, hey, we got a conviction. Our evidence is overwhelming. They're going to say that every time. But we can't just be that if there's a conviction, it was overwhelming. This jury was out for a whole day. They got the closing arguments at 9 a.m. on Thursday. They deliberated all the way until 4:15 p.m. They asked to go home. They came back the next day. They found not guilty on second-degree murder. This was a close call. And when we look at the standard of, was there a reasonable possibility that the outcome of this trial could have been more favorable to Miss Sullivan if this wasn't the first witness through which the lens of sympathy was created for the entire rest of the trial? Is there a reasonable possibility of that?
Mr. Peterson, I think there's another hurdle I'd like you to address with regard to your prejudice argument. And that's the fact I understand the emphasis you're putting on the father testified first. But his testimony was fairly brief. The state's questions were fairly direct. The father went beyond that. The state did not come back to reference that testimony or emphasize it, but defense counsel on closing used the photograph in that testimony, trying to turn it to their benefit. So if that's where the emphasis was put, how do you get around that for prejudice?
And so I think that, and the state mentioned this in their brief as well, that, hey, it could have been relevant under 404A2 and as character witness of the decedent. And I know that's not exactly your question, but it's maybe a roundabout way of answering it, Justice Boomgarden. But it was limited, and there was discussion in chambers, and the state knew it was problematic. The state acknowledged, hey, I get it. I'm not going to ask him about all this. He's not going to cry, and we're going to be fairly quick. But the state did not emphasize it in closing argument. I certainly understand that, but I think that, again, I don't know, I can't get in the mind of the prosecutor here. I know that and all of this is kind of circumstantial, but again, it's the only way we can prove these types of things. But what better way to get it in and not get reversed and not overemphasize it? And you know, one of the things, and I was going to get to this later, but I think it goes to your question with 404A2, the state says, well, this could have been character evidence. But if you look at the father's testimony, prosecutor intentionally does not ask any character-related questions. Doesn't say, Mr. Moore, was your son a peaceful man? Was he violent? And what does that mean? Well, first of all, he knows he can't do that because he can only do that in rebuttal. But second of all, it prohibits trial counsel from getting up there and saying, Mr. Moore, that's interesting that you just testified that way. Are you aware that your son would frequently harass and intimidate and say vulgar things to Miss Sullivan? Are you aware that he strangled her just several months before this? And so I think in a way, I don't know how tricky it is, but it's walking this line. And I don't know how intentional it is. I think it's an experienced trial counsel, but to say, hey, I'm just going to get this picture in. I'm just going to put it up there. I just want the jury just to see this. Here he is. Beautiful, smile, in his favorite place. Get the dog in there, and now we've got that image for the rest of the trial. And that's the lens through which we do it. And I'm not going to hammer it in my closing argument because I know that might get me in trouble. And so I think, you know, this kind of goes into the prosecutorial misconduct argument, which I don't know how much I answered your question, but it was limited. But it's still powerful. It's still powerful. Who this person is matters greatly, and how much the jury has sympathy for it matters greatly. And one of the things when I think about prejudice, and I know we say, oh, you know, we tell the jury in closing arguments in their instructions, don't rely on sympathy. Don't allow that to influence your decision. But if that was good enough, and we trust that the jurors follow the instructions, why do we even have Rule 403? Why do we have this rule against in-life photos? Why do we have a rule against victim impact testimony? It's because we know that there's a danger that the passions of the juries will be inflamed, that it will invoke sympathy, and this is kind of a nuclear bomb right at the beginning of the trial. And so one of the hardest things about proving prejudice, and I love talking about this stuff because it goes back for all these years. And how do I prove prejudice? Well, the only real way to do it would be to go back in time and have the exact same jury and do this trial over again without this witness. And we can't do that, I guess, unless it got reversed and we went back and we did it without that, and then we would have that opportunity. But how can we know what weight this had in the juror's mind? We know it's dangerous because of Rule 403, because of this court's precedents. We know it's dangerous. It's dangerous because it's prejudicial per se. It's prejudice.
Well, Wilkes says it's not prejudicial per se.
Well,
So I think you'd have to get around that. We made it very clear that we look at it under a harmless error lens. But the one part of my question you didn't answer is, if it was so dangerous, why did defense counsel go back to it in defense closing?
yes, thank you, Your Honor. And I think, again, the reason I think this case is so interesting and to talk about is, in that battle of that trial, you got to do what you can. The defense counsel objected, tried to keep the photo out, overruled. Okay, thank you, Your Honor, here it comes. Now it's in. I've got to do what I can do with that photo to try to use it to my advantage. And so defense counsel did point it out. Defense counsel did say, look how big and strong this guy is. Look how big his muscles are. But that wasn't certainly the justification for introducing the photo. The state didn't say, hey, we want to get this in so defense counsel can use it in closing argument. But defense counsel did what they could with that material.
So I think that's interesting, right? So surely if it was admitted over objection, the defense counsel was going to have to do what he could do to minimize the impact of the evidence, which is what I think you're telling us. But then, of course, in rebuttal, the prosecutor came back with and used it for his the reason that he gave as a justification for introducing the evidence. He said, look at where this was and how would it work with the stab wound. So how do we deal with that?
So I think if you go back and look at the initial justifications, the prosecutor says he wants to use it. This is in the pretrial memo. Why Mr. Moore was in the U.S., lay foundation for the picture. Defense attorney objects, go back into chambers before the witness is called. Now the state says, I want to use it to show he was alive, which is different than the pretrial memo, and used by the medical examiner to show the distance of the wound, the distance from the wound to the floor, which is, I think, slightly different than saying where it was on the body and in terms of the hands, because that became a thing later in the trial, and the prosecutor on the cross-examination was getting from the witness, okay, now how were you standing? How was he standing? And I took it that, his arms were out and coming after her, chest high, elbows kind of bent. And so the prosecutor now uses it in closing argument to talk about where it is in relation to the arms, but not from the distance to the floor, which I think is slightly different, and why we can see that there's a problem. That's why it's, I think, a disingenuous reason for offering it in the first place. That's not why he wanted to get it in. He didn't say, Your Honor, I think how this all went down and where exactly that wound is in relation to the arms is going to be important. It's the distance from the floor, which I don't understand. That never came in. And of course, as pointed out, this photo does nothing to do. I mean, this person is kneeling in a lake. And there was never any testimony that the decedent was kneeling in a lake when he went to strangle the person. Now, I think the distance from the floor to the head could be possibly a relevant purpose, but then you have the medical examiner's notes, which is very precise. You have the body on the table. You're able to measure it with measure the distance from the head, and that's actually in the report. And we see that often in forensic autopsies, the distance from the head to the wound, because that can matter, but the state never went there. The state never went there. The state used it in their rebuttal. They touched on it very briefly, but I don't think that even goes to, they say, how could it be right here if his arms are outstretched? Well, it seems pretty obvious to me. But again, I think we're getting back into where we're reweighing the evidence as the jury. The question is, was this evidence so overwhelming that there's not a reasonable possibility that if the state doesn't do this in their first witness, is there a reasonable possibility this could have come out differently? That jury was in there for a long time. And I want to kind of hit on prosecutorial misconduct,
But
but
the fact that the jury deliberated a long time, I don't know if that's really particularly helpful, because they had second-degree murder and voluntary manslaughter, they had self-defense, they had a lot of things to think about. And we don't know. I mean, a day and a half deliberation on a case like this is not extraordinary.
and I agree with that, Your Honor. I mean, I think I'm, you know, if the case says, if the state says the evidence was overwhelming, I don't know, I think I've seen cases that are overwhelming, the jury goes in, they come back out, there's no question about this person's going down. There was a lot to think about here. I don't know how to prove prejudice.
Counsel, I want to follow up with another question for you. In your briefing, you sort of imply that the district court's statement that it would be error not to admit this, it was part of the analysis for the trial, when if you read the entire transcript, I think it was pretty clearly part of discussion about admissibility or use during sentencing. You've got plenty of good argument that this was not relevant. Why go there and arguably mislead the court that was a statement of error of law by the trial court at the trial level, rather than, I think the context was clearly we were talking about sentencing if he was convicted.
Well, I appreciate that, Your Honor, and I went, after the state said that in their brief, I went back and I looked at it. I've read this thing 1,000 times, and I think it's at the very minimum very confusing, but when I read it, I read the court to be saying it in the context of ruling on the motion for admissibility of evidence at this trial. The court says the court will deny your motion to strike, and Mr. Bennett, let me go ahead and deal with something else that you have not said and Mr. Bowers has not said. And then he goes, you've asked that it be struck. Okay, so that is something that Mr. Bennett said. So already I'm like a little bit confused about what has been said or what hasn't been said. If there is in fact a conviction and a victim impact statement, that he not be allowed to testify in that. I'll also rule on that this time, and you can certainly renew it. But I think that a victim impact statement from the father of the deceased is certainly relevant. And in fact, I think I would be committing errors should I not allow it. So your motion is denied. I don't see the word sentencing. I really don't. I would never try to mislead this court. That's how I read it. It sounds to me like, and also, you know, I feel like relevant is a term of art, of evidence about, you know, what the court can consider as sentencing. I didn't understand what he was talking about, but when I read it the first, I mean, I go back, I don't know exactly what the court was saying there, but I honestly read that to say that he believed that victim impact would be relevant at this trial. That's how I first read it. Maybe I read with rosy-colored glasses or something. I say, "Ooh, that's really good for my case," but I never took that to be at sentencing. And I think, and so I certainly did not intend to misrepresent that. That's how I read it. It's in the context of ruling on that motion to strike. And so, but I think regardless of the court's justification, if the court goes up and looks at the paragraph before that, it says, well, Mr. Bennett, Mr. Bowers, Ms. Sullivan, the jury's the one who's going to figure out the value of this information. There's no analysis there. There's no weighing, well, this is a self-defense case. This is, why is the father testifying? Is he going to get into character? I don't feel good about this. Why don't we put a pin in this, see how the trial unfolds? If you want to call the father in rebuttal to talk about him with his dog. I mean, the other thing is the court never looked at the picture, which I don't really put that on the court, which is why it kind of got to the prosecutorial misconduct phase of this, because I was kind of thinking, you know, obviously the court was a little frustrated that the trial counsel didn't bring this up at the pretrial conference, that bringing up on the morning of trial right before the first witness takes a stand, and he's saying, why didn't we talk about this earlier? And there's a little bit of frustration going on there. He says, the court says in there, I have not seen the photograph. Well, maybe somebody should have shown the photograph, maybe defense counsel should have done it, maybe the state should have done it. But I started thinking, well, the poor district court, you know, they're getting this right. The juries were all called, the opening statements, first witness, we're in chambers. Let's get back out there. And so I'm thinking, well, the district court is relying on the state to have a proper purpose for this motion. And Haverina, they talk about how this is the appropriate way to handle an objection to victim impact, is to go back and not be the bad guy. The defense counsel, oh, we've got the decedent's father up here, he wants to show a picture of him. Objection, Your Honor, this violates rules of evidence. And now the jury's going, geez, we can't even hear from the dad. So I think the defense attorney did it right, but I think that's where we get to the prosecutorial misconduct is.
Let me ask you about that. I mean, I think this case turns on prejudice. Is there a different prejudicial analysis between the evidentiary ruling and the prosecutorial misconduct, or is it all kind of one and the same and you either win or lose on that?
That's a great question, Your Honor, because I saw in the state's brief that they mentioned that there was no objection at trial, and so there's a plain error analysis under prosecutorial misconduct. But actually, I think that in Black versus State, this court said we review allegations of prosecutorial misconduct under the plain error standard if there's been no objection. When there has been objection, claims of prosecutorial misconduct are reviewed under a harmless error standard. But the court goes on to say whether such misconduct has been reviewed on the basis of harmless error or plain error, this court has focused on whether such error affected the accused's substantial rights. The accused's right to a fair trial is a substantial right. And then the court goes on to say, before we hold that an error has affected an accused's substantial right, thus requiring a reversal of conviction, we must conclude that based on the entire record, a reasonable possibility exists that in absence of the error, the verdict might have been more favorable to the accused, which is the exact language from the abuse of discretion. Although, I do want to point this out, and I think the court is probably aware of this. The state agreed on abuse of discretion for the entry of the evidence in error that the harmless error standard is a reasonable possibility that the verdict might have been more favorable. I think later in this state's brief they might have used the word reasonable probability. I went back and looked through some of this court's most recent opinions. There's a Berry versus State from September of last year, Croy versus State of December of last year, where it seems to be almost used interchangeably, reasonable possibility versus reasonable probability. I think a lot of the cases from 2024 do say reasonable probability, but I don't think reasonable possibility has been directly overturned. So I think reasonable possibility is still, is there a reasonable possibility that the outcome of the verdict would have been more favorable to Ms. Sullivan under either the abuse of discretion or prosecutorial misconduct? And as mentioned earlier, the reason that we have these rules against prejudicial evidence and against in-life photos and against victim impact is there's a possibility that they will inflame the prejudice of the jury. And so they match. It's a webless seam, or what do they say, seamless web in law school that, yes, Justice Gray.
So, counsel, what I want to kind of hone in on is that clear and unequivocal rule of law, because actually you can't say that the admission of the picture was violation of a clear and unequivocal rule of law, because in some circumstances the picture could be admissible. They gave an admissible reason, the distance from the wound to the ground, and then they didn't use it for that reason. So is the clear and unequivocal rule of law under prosecutorial misconduct the fact that you're making a case that they misled the court, that they never had a legitimate reason? And I guess what I'm kind of trying to drive at is if they had a legitimate reason, and then just the way that the trial progressed, they didn't end up using it for that. Is that prosecutorial misconduct?
And thank you, Justice Gray. I think, the way I read Black versus State is that under prosecutorial misconduct, whether or not the error was preserved and whether or not it's harmless error, plain error, you don't need the clear and unequivocal rule of law to be violated like you do for evidentiary error. And again, I think if the court looks at Black versus State, they say, we're not going to do the plain error four-part test. All that matters under prosecutorial misconduct, the standard review is, were the accused substantial rights violated? Were they affected? And that the right to a fair trial is a substantial right. So I don't believe that under Black there needs to be a clear and unequivocal rule of law. So that would be something to that I could look into, or if the court was to look into. But that's my reading of Black. And but regardless of whether or not there needs to be a clear and unequivocal rule of law, because often with prosecutorial misconduct, we're not going to find a case that's on all fours. I don't know if in Black there was a case that was on all fours, or whether that was a harmless error, but prejudicial error. But I do want to hit on this, that the prosecutor has a special role in our system. They are a representative of the sovereignty. They are a servant of the law. They are a minister of justice. These are lofty terms, and they should be. The prosecutor has an immense amount of power and an immense responsibility. And I believe that's why this court, even if it is under the rule it was not objected to at trial and we're under plain error, it's different for prosecutorial misconduct. It's different because the prosecutor's role is different. They know the law. They should be held to know the law. In Haverina, they say when the defense counsel, if they have to object to this victim impact testimony, the court should get involved sua sponte to prevent the defendant from doing that and in fact admonish the state in front of the jury that they know better, that this evidence is not allowed. And I think what I'm hearing maybe from the court is we all know this evidence is not allowed, especially as the first witness in the trial, especially as the first piece of evidence in the trial. We all know that. The prosecutor knew that. If he didn't, they should have. It's on them. They urged this evidence on the court. Whatever their justifications were, they urged it on the court. The court went for it. It got into the trial. It shouldn't have. And I believe that it's been shown that that would have a reasonable possibility, if that hadn't happened, that this outcome would have been more favorable, and I'd like to reserve the rest of my time for rebuttal. Thank you.
Thank you, counsel. Mr. Burton.
May it please the court, counsel? My name is Donovan Burton, and I'm representing the state of Wyoming in this case. Life doesn't happen in a vacuum, and what we learned about in this case, it started thousands of miles away in Australia and years ago. And the jury learned in this case how events from thousands of miles away and years ago ended in that camper in Lincoln County. That was Ms. Sullivan's opening statement at trial. The first thing she said to the jury was, this case is about Australia and about the relationship that the defendant and the victim had. And the reason why I start with that is I think I disagree that it was irrelevant to start with Mr. John Moore as a witness. I think the state knew from the very beginning of this case that Ms. Sullivan's trial strategy was to drag out all the bad things from their relationship and tell the story to support her self-defense claim. And the state also knew more or less what that self-defense claim looked like from the John hearing. The state was aware of what Ms. Sullivan was going to allege at trial. And the district court even commented, your strategy is to make Andrew Moore look like an evil, nasty individual. The state knew that.
But, counsel, how is the picture relevant to that scenario you just painted? What relevance does the picture have to any of that?
I would say John Moore's testimony was relevant to that. The picture was relevant, as the state said, to illustrate the self-defense claim. And maybe I clean up what the state said a little bit. I perceive the state's argument as kind of holding its cards a little. And you have to recognize that Ms. Sullivan had not testified yet. There was still a chance that her description of the self-defense from the John hearing could have changed at trial. So the state wasn't going to...
Isn't that rebuttal evidence then? Wait and see what happens with the defense?
Perhaps, and that goes to the medical examiner, I believe, as far as the state not calling the medical examiner for this purpose. The state had to wait until after she had presented her testimony.
So how does the picture of the victim kneeling at a lake with a dog or a puppy have anything to do with his height or the height of the wound or anything else? It seems to me that's a real stretch, and that it was used for the purposes that the prosecution argued to get it in.
I think the broad purpose that the prosecution argued was to illustrate the self-defense. I do think that is what the prosecutor said in talking about the distance from the wound to the floor. And Mr. Peterson kind of illustrated what he believed Ms. Sullivan's testimony about self-defense was. I kind of disagree with that from the record. Ms. Sullivan says she was on the ground, and Andrew Moore was hunched over top of her with his arms reaching down towards her neck when she stabbed him underneath his armpit. And the state pretty clearly pointed that to the jury during closing argument in its rebuttal closing, illustrated what Ms. Sullivan had illustrated to the jury, said it's not possible. You don't stab someone under the armpit when they're in the position. And this picture, it illustrates that position. Ms. Sullivan gave conflicting testimony about whether he was standing or on his knees, but the idea is that he was hunched over and reaching down. That picture does illustrate that.
But, Counsel, they never used it for that purpose, except for in the rebuttal argument. This is the first time they brought up the location of the wound as it related to the picture. And they did that because I think the defense was trying to mitigate what they thought was the damage from the picture. So they were using the picture for its own purpose. And so I guess the same as I asked from the defense, I would say, is the fact that the defense used it, tried to mitigate what they thought was the impact of the evidence, does that limit or minimize the prejudice analysis? And does it change the way that we look at the state's either prosecutorial misconduct or the court's error when the state never uses it for what its stated purpose was until the rebuttal and closing?
Well, I think as far as the state using it for that purpose, they would have had to wait until their rebuttal case to do it. They did not put on a rebuttal case involving the medical examiner, but they could not have done this during their case. They could not have had the medical examiner say, I've reviewed what Ms. Sullivan said happens and this is implausible. You have to wait until she testifies to that. So as far as using it in your case in chief, the state couldn't have done that. And they would have had to recall the medical examiner to get in what I think the state recognized from Ms. Sullivan's testimony is, we don't need a witness. We can just ask the jury, think about this. Think about what she said and what she described, and look at this picture as an illustration. It's not plausible. That's what the state said. They had to be standing.
Well, then, what's your position on Mr. Peterson's argument that that purpose that you've described is unrelated to the purposes that were provided prior to trial?
Well, the purposes that were provided prior to trial, one of them is to establish identity and show that he's alive. I would agree that those aren't necessary, but I would also point out this court has said that they are things the state needs to prove, and they are reasons to show a picture of a victim. And so the state did that purpose. I would say that's not the strongest, but I kind of disagree with characterizing what the state argued about the wound to the floor was not exactly what the state did. I think that's exactly what the state intended to do. They went out and looked for this picture and found this picture for the reason that it puts this into context. It wouldn't be the same if it was just a picture of his face. They chose a whole body picture. And as far as the state's reasons advocating for this evidence, maybe we should talk about what was actually preserved as an objection. I don't believe there was ever a specific objection to this picture. The objection that preserves the abuse of discretion, it was a motion to strike filed before the witness testified on the first morning of trial. And it was speculative based on, we think this witness is going to cry. We think he's going to tell stories of better days. And they mentioned the picture in there, but they were objecting to having John Moore as a witness. And when the state sought to introduce the picture at trial, showed it to defense counsel, he said no objection. So I'm not 100% sure that there's really a preserved objection or that the state really advocated for the admission of this at that bench conference before trial. And the point I guess I'm trying to make is that their objection was really broad. It was nothing specific was objected to. Just the idea of having John Moore as a witness was objected to. And I think the relevance is we're telling a story that started in Australia. Both sides agreed that the relationship between Andrew Moore and Monique Sullivan was relevant. It was absolutely going to be relevant in trial.
So, James, I have a quote here that the defense argued that the photograph of Moore with the dog would be an inappropriate attempt to pull at the jury's heartstrings.
that that was baked into the motion to strike the witness. It was not an independent objection to the picture. They were grouped together, and we don't ask this court to apply plain error to the picture, but I'm just pointing out that there wasn't a full-fledged argument about this picture. There was not a full-fledged objection to this picture. The district court did not make that type of ruling regarding this picture. The court kind of resolved this broad, what the court perceived as an untimely objection, and one that, again, it was speculative. It was premature to strike testimony that hadn't been given.
Mr. Burton, I'd like to take us back to the prejudice analysis. So you started your argument this morning by telling us that the testimony, the photo, was relevant because the state knew she was going to make a self-defense argument, and the picture that she was going to make to support that argument. If that's the case, and that was the basis for the relevance of the questioned evidence, does that not then heighten the possibility that erroneous admission of that evidence was prejudicial in context of the self-defense defense? In other words, Mr. Peterson started too by saying this was self-defense, so it was prejudicial if you look at it through that lens of self-defense, and it seems to me maybe you've supported that by saying this was relevant because there was self-defense. So if it was erroneously admitted, maybe we need to take a little closer look at that, or that look at the strength of the state's case only through that self-defense lens. So I'd like your response to that.
Relevance and prejudice work together. When something has higher relevance, we can expect it to be prejudicial, and prejudice is okay. Relevant evidence tends to prejudice the defendant. That's why the state puts it on. It's unfair prejudice this court is looking for. So by pointing out the relevance of it, it is somewhat prejudicial to her self-defense case.
But if it was erroneously admitted on the state's theory that it was relevant for that purpose, does the fact that self-defense was her defense not make it more likely that if that evidence erroneously came in, there was a greater possibility that her verdict would have been more favorable without that evidence?
I understand the question, but where I'm struggling is if it was in for a relevant purpose and used for a relevant purpose, it could not be erroneously admitted. Because to show what they have to show on appeal, they have to show little or no relevance and extreme inflammatory and prejudice. And so what this court is realizing is that, yes, you do talk about the background of a victim. You do talk about the context of the relationship, and you do illustrate what could have been going on in that camper for a relevant purpose in conjunction with self-defense. It is prejudicial.
So maybe, just maybe to clarify, I appreciate that that's the state's argument why it's relevant. I think you've heard from this court today there are a lot of questions whether it was relevant. So you need to maybe be open to the possibility that we find that it wasn't and it was erroneously admitted. So that's all I was saying.
Yeah, and I certainly understand where this court's going with that. And my point I'm making there is that if it heightened the prejudice for self-defense, it's because it was relevant to self-defense to talk about it.
But it was preemptively relevant, right? So they put it in. I think that's maybe the problem is that, so they put it in anticipation of what she might or might not say. And apparently it only became relevant during the rebuttal closing argument, because that's the first time anybody mentioned the reason that was given, the valid reason that was given for its admissibility.
Yes, I would agree with that, and I understand that.
So counsel, following up with Justice Bloomgarden's question, the defense counsel argues that possibility, well, that's not, it's reasonable possibility or reasonable probability. Maybe we've used those terms interchangeably. Is there a difference, and do we need to address that? And is there a difference between the prejudice of the admissibility of this versus the prosecutorial action or misconduct that's alleged, is it the same prejudice analysis?
I wouldn't say it's exactly the same. It's somewhat different. With prosecutorial misconduct, we're looking at did it deprive the defendant of a fair trial? With evidentiary error, this court's looking at a reasonable possibility or probability of a different verdict. I think you could say that those are the same thing with different words. I don't apply that standard, this court does, so I don't exactly know if this court applies it differently, but I would say there's no prejudice under any standard in this case. First, it strengthens the state's evidence towards self-defense. Because I do agree when you're looking at prejudice, it's not, did the state prove that she stabbed him? That was never an issue. It's, did the state prove that she did not act in reasonable self-defense? And what we have is the physical evidence couldn't have supported the reasonable self-defense. None of it matched what she was saying. That a scuffle happened in the camper with a witness who was just a few feet away, who heard yelling, heard the appellant yelling at the victim, didn't hear the victim yelling, didn't hear a physical altercation until he said, "Why did you do that?" Until what the witness who was right there, Stacy, said, "It sounded like unprovoked." And that all goes to, there was not strong self-defense evidence. I do believe that the big debate between the jury that Mr. Peterson talks about took him a whole day. It was between second-degree murder or voluntary manslaughter. Could we find a heat of passion here? I don't see strong evidence at all supporting self-defense besides her testimony, and on the same grounds that this court is concerned that a few statements from John Moore about who his son was and where he came from, that was irrelevant. Read through the appellant's testimony. There's pages and pages of stuff about things that happened in Australia, the dynamics of their relationship in Australia, things that, for the same reasons they say John Moore's not relevant, she argued it was relevant. She presented that evidence.
But that's not really our standard, right? Our standard is the prosecution has to, prove the elements of the crime, not address everything that she addresses in her relationship, because really nothing that he testified to rebuts anything that she has or goes to an element of the crime.
It does remove the conceptual void in the case. It explains who are the players, what happened, how did it happen, where did it happen. I don't think you can just start your trial with a detective. Hey, I found a guy who was stabbed. I found a person who said she did it. You have to lay background. You have to introduce the jury to the story that you're going to ask them to find beyond a reasonable doubt that this happened. And the state gets to pick how he's going to chronologically present his case. You could start with law enforcement. You could start with scientists. Or you could start with a witness who the state knew was going to be relatively neutral in the way he testified.
And counsel, it looks to me like John Moore was relatively neutral and brief. I think the true concern is the photo. So could you just really address that specifically?
I would say the photo is equally neutral. When I think of a prejudicial photo, some of the cases, this court has had prejudicial photos. In a sex offense case where they picked the youngest looking photo of the victim the state could find to really show an innocent victim. That's prejudicial because we see what you're doing there. Or you could have a photo of a murder victim with a child, to remind the jury, hey, this is a father who's never going to get to see his kid again.
Isn't a photo with his favorite dog at his favorite lake kind of in line with that?
I would say kind of, but not close. I understand. I understand that there's a dog and that supports their argument. This wasn't a photo of a dog. There wasn't talk about the dog. There was one line of testimony, the little dog he brought home. There was no development of that. And the Solis case talks about that. The state was building a hue of sympathy throughout the whole trial. I don't think that one line and the fact that there was a picture involving a dog made this case about a dog. It was not. And the district court even said that when ruling on the photo. Are you asking me to crop out the dog? Because you haven't argued that. They weren't really challenging the dog. Now they are, but that was really not directly what they were getting at. I do think the biggest thing they were objecting to was John Moore. And the photo may seem like the better argument in this appeal, but I still think it was a relatively neutral photo. It was not overly sympathetic. And I think when looking at it, my first thought is what Ms. Sullivan's attorney argued during his closing argument. It shows a big, kind of scary guy. I don't think it showed a person. It didn't show a different picture than what the evidence showed of Andrew Moore. This photo did depict exactly what we were talking about at trial, and it allowed the jury, look at this photo and imagine, could he have been coming at her? Would it have been reasonable to act in self-defense if he was coming at her? I think it was a fair photo for that reason.
And counsel, you're kind of getting to what I wanted to ask you about, so maybe elaborate on it a little bit. We have this four-part test for substantial or material prejudice. The strength of the state's case is obviously the most important factor. We've talked about that, I think, pretty significantly. How the evidence was used, we've talked about that. The third factor is whether the evidence related to a material and consequential fact. So walk us through how that factor works in support of your argument.
Thank you for the question, and I hope my brief was clear on this. This is where we talk about 404A2. This is where we talk about the idea that if the state wanted to structure their case to say Andrew Moore was a happy and peaceful person, they could have. And so what they're complaining about as prejudicial could have come in for character reasons if the state wanted to. And the state chose not to go down that road during trial, but when this court looks at prejudice, we're talking about something, this never should have come in. That's when this court, it weighs heavily in a prejudice analysis. This could have come in. The state could have argued, hey, here's why we need John Moore to testify.
But they didn't. I mean, isn't that the problem?
And that's why I talked
But
about.
they didn't bring that in. They didn't offer that as a reason. They didn't say that they wanted to portray him as a nice guy with a very peaceful past. They said, hey, we want it to prove that he's alive. And we said that's not a relevant reason. And they said, hey, we want to prove that the distance of the stab wound. And that was sort of preemptive to the self-defense, and they never really used it for that purpose. And right off the top, I'm asking the question, I can't remember the third reason, but that third reason, none of which, and they didn't use it for the point that you just argued about.
Correct, and if they did, I would be arguing that it was relevant because they used it for that. And I'm arguing it's not prejudicial because it could have been used for that. And again, it goes to the idea that this court is looking for whether it's misconduct or evidentiary error. This court is looking for something that shouldn't have been there. Something that we can just look at it and say, this would throw a jury off.
Well, hypothetically, so I get that, but I just want to follow up on that for a minute. One possibility is that they didn't bring in his peaceful, wonderful character because that wasn't true. And so they didn't have that opportunity to bring in, but they bring in a picture that implies that character because they couldn't get it in otherwise. I mean, I can see a lot of reasons with speculating that if they would have brought it in for this reason, then it would have been admissible, and then it would have been prejudicial. On the other hand, that could be that it's absolutely prejudicial because they couldn't bring in that evidence any other way.
I would say that that's actually untrue, that he had a bad character. And there's a lot of cross-examination about that. There's a lot of this insinuation through Maya and Stacy, who were the witnesses who were there. You know, have you ever seen anything that looked like Andrew Moore attacking Monique Sullivan? No, never. In 8 years of knowing that. So there actually was evidence of his good character, admitted. That's not an issue. It wasn't admitted through his father. It was admitted through the people who were there, who saw these interactions in the days leading up. But I would say that the state, it's wrong to say that the state chose not to get character evidence from John Moore because Andrew Moore had a bad character. I think that the evidence at trial.
But none of that's in the record, just as the other side of your coin. I was just saying there's another way to view that, right? we can't go with what's not in the record. They didn't ask for it to be admitted because it showed his character or something like that. I mean, your argument was that would make it admissible, but that's not what happened.
And again, I disagree that it's not in the record. It is in the record. It's in the record that Andrew Moore had a character for not domestic violence.
It's not in the record that the picture was admitted to show that he had a good character, or that's the reason the father was going to testify.
Correct, and certainly the picture, I don't think, had any character use. It had use for illustrating the self-defense, illustrating that, and just allowing the jury to see, here's what we're talking about. I think that's what the picture. And when we talk about character, that's more about John Moore. And again, I do think John Moore could have, and I think that's important in the prejudice analysis. To know this isn't evidence that never could have come in. It's evidence that came in, and if this court finds it's irrelevant for the reasons proffered by the state, then this court is saying the state didn't use it for what it said it was going to use it for, but that doesn't mean it could never have come in. It could have been relevant. It wasn't that type of distracting stuff about, like the Solis case, about how the victim vowed never return to Powell after the crime. She quit going to school, her grades started dropping. All of this is saying, this never should have been there, and all it does is tell the jury, hey, find him guilty because you feel bad for this victim. That's the problem. Nothing that was admitted in this case was used in that manner, and because it has so many possible reasons for its use, the jury wouldn't have picked up on that. The jury wasn't sitting in that deliberating room saying, well, he had a dog, so she's guilty. That's far afield from what could have happened based on this picture. And again, this wasn't over and over again mentioning the dog. Where cases like Solis, it's repetitive. It's over and over again going back to what this court is saying, you need to be really careful when you go in this area. And the state keeps going there. Here, this was all very brief. The picture was used in 2 brief instances during evidence just to have the father and the appellant identify the victim. And there wasn't extensive questions. There was no talk about his appearance in the picture until closing argument, when the state said, here's what we see here. Here's what we see in this picture, and here's what we want the jury to see. And again, the state could have called a witness to talk about this picture and draw on it and show, here's where the stab wound would be. Could have done that, and the state just said, the jury can draw that as an inference. The jury can look at this picture, think about what they saw depicted to them, and say, we agree with the statement. They had to be standing. And that was the ultimate purpose the state had with the picture. And just to briefly touch on the prosecutorial misconduct argument, the way I read their argument, they're saying that the state violated a duty of candor by saying the medical examiner may testify about this. And again, I think the state's use of it shows exactly what it was trying to do. And as I mentioned earlier, for the medical examiner to have testified effectively about this, it would have had to be in rebuttal. And the state just chose not to do that. Either they didn't see a need, the timing didn't work out, for whatever reason. The state didn't call the medical examiner in rebuttal for that purpose, but the state still did what they said they were going to do. That they used it to illustrate. And finding a case that talks about this, I agree with Mr. Peterson. I couldn't find one that's, got the exact same fact pattern. We cite to the Dickey case from the 1960s. This court was saying it's not misconduct unless there's a substantial or prejudicial departure. And I don't think this was substantial or prejudicial from saying we're talking about the location of the wound. That's what the state did with the picture. And so I would say that there was no violation of a duty of candor in advocating to the court for the admission of this. And maybe I'm backing up with the Wilkes case. the idea that it is a clear and unequivocal prohibition on in-life pictures, I think that's how this court came out in that case, but the things this court says in reaching it, it's more wishy-washy than clear and unequivocal. This court says you do have the burden to show the victim was alive. You do have the burden to show identity. So this court didn't say, get out of here with pictures. This court.
So is it a plain error standard of review on prosecutorial misconduct?
Yes, I would say it has to be. I would say if there was a timely objection, hey, they're never going to use it for this purpose. They're lying to you, court. The court needs to really do some analysis of that. We don't have that. And now in hindsight, with the way everything played out, they're saying the state was lying when it said the medical examiner may testify about this. I think this court has to apply plain error to that. And this court has to look at the whole record when evaluating that. Because there was no objection. Nobody was ever on notice that they believed the state was misleading the court by talking about the medical examiner.
Well, how could they have known? Because that whole discussion occurred prior to calling witnesses.
I mean, if someone says something that jumps out at you as implausible, you say, I don't see that at all. I don't see how you could ever use this for that purpose. I object to even saying you have that purpose. And that wasn't done. And again, the picture actually wasn't objected to when the state sought for its admission. So I don't think anyone could have perceived at the time that there was this accusation of violation of a duty of candor. And that's what plain error is. It's to say the court should have jumped in and said, hey, I don't believe that for a second. And I don't see this meeting that standard. But either way, the analysis is very similar, plain error and abuse of discretion. You're looking for was there an error and was there prejudice, and the state maintains for both of those. There's no error, and there could be no prejudice when viewed in isolation or when viewing the case as a whole. This was a strong case. The claim of self-defense didn't make sense, and if there are no further questions, the state respectfully requests that this court affirm the judgment and sentence in all respects. Thank you.
Thank you, counsel. Rebuttal, Mr. Peterson.
Oh, thank you, Your Honors. And I'll be brief because I have to be. But I heard a lot about it could have been used for this, or it could have been used for that, or maybe it would have been proper, maybe it would have been proper character, or it could have been used as character. Well, I think there's several problems with that. One is, and I know that maybe the court doesn't want to belabor whether it was properly admitted, this picture. If it was character evidence, which I don't think it was, 404A2 is very specific that the prosecution cannot introduce character evidence of the victim's character unless to rebut the same by the defendant, which of course is the first witness that couldn't have happened. I went back to look at the opening statement because I think there are some case law that says if the defendant's attorney says something about, this is a terrible guy, he's violent, that maybe that opens the door. That didn't happen in defense opening statement. And there's a reason that 404A2 exists. We cannot front load this he's a nice guy character evidence. In the states, I think what they're saying is, okay, yeah, I agree that identity, why he was here, those kinds of things weren't really that important so it couldn't have been that prejudicial to that, but it was really prejudicial to her self-defense claim. That's what it went to. But she could have done that if we would have done it in rebuttal. But here, the other thing is, this picture, as the court noticed, is not character evidence. This is not evidence, as the court noted, that he's a nice guy, that he's a peaceful guy. It's a sympathetic picture. It's sympathy evidence.
Counsel, I think the 404A is red herring. What about the weak self-defense case? I mean, that seems to me right on the prejudice issue. The self-defense was so weak that no harm, no foul. Affirm.
Gotcha, Your Honor. And yes, prejudice, I think, is the big sticking point here. And again, if it was ever going to be prejudicial, it's going to be in a self-defense claim. You've got a 5'3" female, 6'4" male, one stab, lonely cabin. I mean, there's a lot of evidence of self-defense here. The jury ultimately did not buy that. And why? I don't know. Was there a possibility they were swayed by their sympathy? It's possible. There's a reasonable possibility. I understand that the state has evidence it was not committed in self-defense, but I think there was a fair amount of evidence that this, I mean, that we don't have eyewitnesses saying, oh, I saw her, she definitely did this. He wasn't attacking her at all. This is in a lonely cabin out in the woods, and it's a tough one. My client's not the big guy that's stabbing the little girl with her back to him. I mean, it's in the front. It's in an area where he would have been attacking her. They're in close quarters. I mean, I think there is a lot of evidence that could be seriously considered here. It's not overwhelming. And so, but even if it were, there's the other factors to consider. Was it used in this way? And the final thing I'll say is and I think the court was onto this as well. The state argues this is a neutral picture. I cannot think of a more sympathetic picture, and I know we talked to maybe somebody with their newborn baby or something like that. I don't know, a lot of people like dogs and puppies more than babies, but, I have dogs, I don't have any babies. Picture of a guy with his dog in a lake having a good time recreating in Kemmerer, Wyoming, southwest Wyoming, where people love to go to the lake with their dogs. It's as sympathetic of a picture as it gets, at minimal relevance. There's a possibility it affected this verdict. A reasonable possibility, I think so. And I think there is there is a difference for that, and certainly would advocate for a reasonable possibility. Something that is possible is much more likely or easier to show that it's possible rather than showing that it was probable. So a reasonable possibility. And because there's a reasonable possibility that this very sympathetic picture influenced the outcome of this trial, we'd ask this court to reverse and remand. Thank you.
Thank you, counsel. Thank you both for your arguments. The court will take this matter under advisement for issuance of a written opinion at a later date. We will stand in recess until further notice, but we're going to hang out here for just a minute and tell you what's happening next. Shauna, correct me if I'm wrong. The court's going to go take our robes off. We'll be right back. We're going to do the mock oral argument. We need 4 volunteers. Do you need an assistant? For 4 volunteers and a 5th if somebody really loves whacking the gavel. No. All right, so we will be right back. Don't go away, and we'll meet with the volunteers when we get back.
You got it? Test, test, 1, 2. Check, check. Test. Test, 1, 2, 1, 2. You all probably wondering why I called you here today. Test. Oh. Check, check. Okay. I'm gonna turn it off.
Instructions and organizational setup, we wanted to take this opportunity to present an award. We were really happy that we were going to be in Natrona County and specifically at Casper College for this purpose. So the Judicial Branch, through the Judicial Council, has a strategic plan. And in that strategic plan, a priority is access to justice, because that has become an increasing problem across the nation. The number of people who have a need and have a requirement to be in court don't understand the process and can't afford an attorney. And so one small answer, the answer to that problem is very complex, but one small part of the answer has been the establishment of what's called a court navigator program. And a court navigator would be a non-attorney who, and it's generally a volunteer, who then has agreed to assist a non-represented litigant, whether that's in a criminal matter or in a civil matter, generally civil, with filling out of paperwork. And so they will do some things like maybe somebody comes to court and they'll orient them to, this is where the courtroom is, this is where the clerk is, this is how you know what time you're supposed to be there, this is how you'll get called up. Or maybe the filling out of pro se divorce forms, or different kinds of things like that. So Wyoming thought that we would try to go ahead and set up that program, and that the best way to do that would be a pilot program. And so here in Natrona County, the judiciary, the district and circuit court judges, the clerk of the district court, and the college came together to be really more than partners, but leaders in that effort in Natrona County. And so as part of that effort, there's established office space for the navigator at the Natrona County Courthouse. There are a number of folks who've be volunteered. In order to be a volunteer, you have to have a series of live training to understand. And there's a kind of a key difference between a navigator and maybe an attorney that would help a pro se litigant, and that is the navigator can go ahead and provide assistance in filling out the forms, but they can't provide legal advice. And so there's a nuance there that's important, that's part of the training. And so in Natrona County, Amanda Nelson, who is in charge of the paralegal program here at the college, made really over and beyond contributions that have driven the success of that pilot here. So in a very short period of time, the 75 individuals have been assisted. In fact, there are more volunteers hours available than there are participants, even though the participant number continues to rise. So since April, that program has also already initiated an expansion into Uintah County, where the Natrona County volunteers via like a Zoom program are going to go ahead and help people in Uintah County.
So Amanda, as part of the recruitment of volunteers, established that there could be a scholarship program here for her paralegal students. She also went through the program and the training herself before she would commit her students, and then she established that there could be some credit for externship for those students who would participate in the volunteer. Those were creative, focused, and important efforts that have resulted in a huge success here in Trona County. And so today the Supreme Court wanted to recognize Amanda Nelson for her efforts and for the assistance that she has given us in the successful beginning of the Navigator program in Wyoming.
All rise.
Madam Chief Justice, Associate Justices of the Wyoming Supreme Court, and of course, Mr. Silva. Seek justice, but love mercy is a phrase that was taught to me by one of my favorite mentors when I had just graduated from law school. And although I've forgotten about that phrase, when I was assigned to this case, it came rushing back to me. And it came back to me for many reasons, partly because MS, who was a minor, he was 11 and 15 when 2 sexual offenses occurred, has been forced to register as a sexual offender now that he is an adult. He's been doing that for 7 years, and he's come to the court seeking mercy. That's why we are here today. Mercy pursuant to the 8th Amendment of the United States Constitution that prevents the state from enacting cruel and unusual punishment on its citizens. And we believe and respectfully maintain that forcing a minor who is now an adult to register as a sex offender for crimes that occurred while he was a minor is cruel and unusual for several reasons. First, these registries can affect where a person can live. It can affect their jobs, their ability to advance through those jobs. It can affect their social life and stigmatize them throughout the community. But perhaps worst of all, it eliminates the juvenile's right to confidentiality. And we know that juveniles because they are juveniles, sometimes they don't make the best decisions. Their brains are still developing. They are more susceptible to peer pressure. And so the law, in its mercy, allows juveniles to have confidentiality so that while they're minors, that whether they committed a crime is going to typically be kept confidential. But forcing a minor to register as a sex offender takes away all of that confidentiality, and I believe tries to get another pound of flesh from the minor who has already atoned for his sins.
Counsel, MS is not a minor now, correct?
That is correct.
So they're not forcing a minor to register, they're forcing an adult to register.
An adult, yes.
Does that make a difference?
Your Honor, I don't believe it does. I'm not arguing that adults should have to register as sex offenders. The adult registry seems to not be enacting punishment because it's simply publishing information that's already readily available to the public. It's different in this case because MS was a minor when these occurred. This is not public information, and by making him register now that he is an adult as a sex offender takes away all of those protections that he once had. And if you look at the Colorado Supreme Court case with very similar facts, the Colorado Supreme Court also determined that having a minor who turns an adult register as a sex offender is cruel and unusual because we want minors to be rehabilitated. We want to give them a second chance, and having them register as sex offenders now takes away all of that protection that they were once afforded. These registries punish young, I'm sorry, madam.
Can I ask? So in
Yes.
the Colorado Supreme Court brief that you're talking about, in Colorado, they don't have the ability to appeal that decision, so to petition to have their name removed. But in Wyoming, isn't it the case that after 10 years, you are able to petition to have your name removed from
Yes.
the list? And doesn't that offer more of an opportunity, if you are rehabilitated as a juvenile, to have your name removed from the list if a committee finds that you have in fact been rehabilitated?
Right. Yes, thank you, Madam Justice, for that question. The reason why we think it's different is because 10 years is a substantial amount of time for the damage to already be done. A 10-year registration time period punishes a minor essentially forever, even though, because after a 10-year period, 10 years of registering, the damage has already been done. We submit even after 6 months, the damage has been done under those circumstances, and that's why we believe that requiring a minor who turns an adult to register for sins that were committed when he was perhaps 5 years old, let's say, for him to be punished for the rest of his life, even though he has completed probation, he's completed treatment that has been focused towards what he has done, is cruel and unusual, and I believe he's protected under the 8th Amendment from having to register at all as a sex offender.
Counselor, I have a question.
Yeah.
You brought up the age of 5 years old, and you said that MS was convicted of crimes that happened at 11 and 15.
Exactly.
My question is, obviously the court found there was significant evidence to convict him of said sexual offenses, and he wasn't 5 years old.
Right.
So my question would be, is it really cruel and unusual if there is evidence that he knew what he was doing when he committed the crime?
So yes, he was adjudicated as a delinquent. He wasn't 5 years old. Thank you for pointing that out. He was 11 and 15 when these occurred. But what about the circumstance when we have a 5-year-old who commits a sexual offense and is adjudicated as delinquent and needs to be punished for that? Is that going to follow him until he's 27?
Well, I'm glad you said follow. My second question would be, in consideration to the victims. Does that not follow them for the rest of their life?
Definitely. Definitely. I believe you're right about that. And the last thing I want to do today is minimize the trauma to victims. I'm just seeking to uphold the Eighth Amendment, in which our founders told us that we cannot cruelly punish people. And so once someone has committed a crime and they have been rehabilitated, they have sought treatment, they've completed their probation and the terms of their sentence, that's when we give them a second chance. Part of that is also sometimes making retribution, not retribution, I did not mean to say that, to reconcile with the victim, either through paying their therapy bills or for other charities that would support this victim. So part of that, but I don't want to minimize bad behavior and trauma to victims. I'm just trying to humbly suggest that the Eighth Amendment protects minors from a crime that they commit when they're sometimes very young, from punishing them for the rest of their lives. So I will rely on my brief for the remainder of my arguments, and thank you, Madam Justice. Oh, Sis, for your time.
I do have to ask because you already mentioned this, the Supreme Court has ruled that it is not cruel and unusual punishment to an adult. But
Right.
the reasons you're citing are problems with housing, problem with jobs, that in as adult, and they are now adults when they are going through this registry. I want to know how that is exactly punishment now, because they've already ruled that it's not.
Right. So, right, partly because they're publishing information that's already in the public. There's probably been newspaper articles about what this adult has done. You can probably just Google his name and it's all going to come up. The difference is because MS was a minor when these offenses occurred. And so it takes away, where it wouldn't with an adult, with a minor, it takes away all of the confidentiality that minor was one time afforded. And that's, we're taking away the second chance we give to minors, because the law in its mercy considers the crimes of minors to be less reprehensible because they are so young. So I would like to rely on my brief for the remainder of my questions, and this has been delightful for me, and I really hope I win this one. So thank you.
Thank you, Counsel. Mr. Silva.
May it please the Court. Counsel, my name is Craig Silva, and I stand here before you today representing the state of Wyoming on this appeal. Today, we're addressing a matter of constitutional interpretation. The issue is basically whether the requirements for minors to have to register as sex offenders under the Wyoming Sex Offender Registration Act constitutes cruel and unusual punishment, either under the Eighth Amendment to the United States Constitution or Article 1, Section 14 of the Wyoming Constitution. MS, who's an adult today, the appellant in this case and the petitioner below, a man now, is burdened by the requirements of having to register as a sex offender for crimes he committed, as you know, when he was 11 and 15. Because these convictions, MS is required to register as a sex offender under the Wyoming Sex Offender Registration Law. This is not an isolated case. Every state in the United States is required to have sex offenders register, whether they're a minor or an adult, when the offense was committed. The federal act is called SORNA, and that's the Sex Offender Registration and Notification Act. And SORNA, in its previous acts, required the states, basically forced the states to adopt similar legislation at the expense of losing federal funds. And so let us take a moment to reflect back on the origins of these laws. They were born from the tragic crimes going back to the early 1980s and the 1990s. The movement for sex offender registration gained its momentum then. And so in 1994, Congress passed the early laws, and the early laws were like the Wetterling Crimes Against Children and Sexually Violent Offender Registration Acts, which basically laid the groundwork for the federal law. In '96, the state legislature in Wyoming adopted what we know today as the Sex Offender Registration Act. It's this powerful legislative history, which is really the first component to determine whether it's punishment or not, but it's this powerful legislative history that underscores the seriousness for which we approach this issue. Now, after 7 years of compliance with the registration requirements, MS seeks relief from his burden to register. He's brought forth a challenge in the district court. He was unsuccessful there and has now brought this challenge as the appellant up to this court. First, and the most essential question that we must recognize is this is an issue of first impression in Wyoming. There's no precedent in Wyoming that directly addresses whether the registration requirement for minors infringes upon their constitutional rights. However, we must ground our analysis with the historical context of the Eighth Amendment, which emerged from a long-standing rejection of barbaric punishments evolving over time to encompass protections against disproportionate treatment. Yes, Your Honor.
Well, this brings up the threshold question, I think, and that is, if it's not punishment, does it even implicate Eighth Amendment analysis?
And that's the critical part, is whether we determine whether it's punishment or not. That's the question we have to ask. Does this amount to punishment? And just on a super basic level, just on a structure level of writing a statute, the statute consists of elements when we write it, and then at the end of that is the paragraph that involves what the penalty is. Okay? That's not how this statute's structured. It's not structured like that at all. And if we look at historically the Eighth Amendment goes back to 1691 in the original English Bill of Rights. In the United States, it goes back to 1789 in our Bill of Rights. That's 300 years, which really tries to stop barbarism and not this issue related to whether you have to register as a sex offender or not.
Counsel, a little more recently than that, the United States Supreme Court and the Wyoming Supreme Court both recognized that youthful defendants were entitled to different consideration under the Eighth Amendment because of their youth, right? Like Miller, Roper, Graham, Bear Cloud in the Wyoming Supreme Court.
Sure. Is that the question, Your Honor?
That is a question. I'm trying to bring you about 200 years forward.
Gotcha. The cases that you refer to are Miller versus Alabama, Graham versus Florida, and Roper versus Simmons, which really launched off from Arkin versus Virginia in 2002. The juvenile cases, though, are Miller, Graham, and Roper versus Simmons, and Roper's the big case that the Chief Justice is referring to. In Roper versus Simmons, the juvenile committed horrible acts. They were the most heinous murder cases that you can ever imagine. I've had to argue cases related to Roper versus Simmons, so I'm very familiar with it. The acts are the worst, horrible things that you can imagine that a juvenile could do in a murder case, tying people up, throwing them in the river, all sorts of terrible things. That state court upheld the death penalty for that defendant, and the United States Supreme Court reversed. And the United States Supreme Court reversed for all the reasons that you would think. All the reasons that Ms. Anna Reeves-Olson talks about as it relates to mercy for young people, because young people's brains haven't developed. We don't want to close the book on them when they can actually have a life. And so what Roper versus Simmons said is that you can't have the death penalty for a minor. Okay, now compare that apple to the orange of sex offender registration. We're not talking about the death penalty. We're talking about having to register so that the community at large will know whether they have a sex offender within their midst. The type of information you give is the same type of information you would give if you get your driver's license. Now it's more, but it's the same type of information. So death penalty is an apple, sex registration is an orange, and it's not fair to compare those apples and oranges.
Well, is it fair to say the fruit that we're talking about is the fact that juveniles are entitled to a different kind of treatment because their brains are still forming, they're more subject to peer pressure, all the reasons that the court applied in Roper, are they not also applicable in the case of sex offenders?
They are applicable I believe, in the case of sex offenders as to punishment for sex offenders. We're back to the Eighth Amendment, Your Honor. We've circled completely around and back where we're at because this is not punishment. It's not. And so how do we know? Well, we know first from the legislative intent. Congress, when it formulated the first SORNA statute, said that it wasn't punishment. But if we look at the case law that is developed, the United States Supreme Court in a case called Smith versus Doe considered the Alaska sex offender registration statute and said that it was not punishment. Now, I didn't say anything about it in the context of the juvenile, but when it has come up within the circuit courts, and it hasn't come up a lot, but when it has come up within the circuit courts have sided with the government saying that it doesn't amount to punishment. We know it's not punishment because it has no form of imprisonment. I mean, let's consider the nature of the registration and the relief itself. Unlike imprisonment, which undeniably restricts freedom, the registration process doesn't impose such restrictions. It doesn't impose such restraints. Adults or minors aren't prohibited from the right to move, the right to change jobs, and/or pursue education. The requirements to provide personal information, while burdensome, and I'll concede that it is burdensome, are akin to those faced by citizens who register to vote or obtain a driver's license. These are not mechanisms, that is the registration process, are not mechanisms of punishment. They're administrative processes designed to ensure public safety. Historically, it's crucial to recognize that registration has traditionally not been punitive. The goal is not to stigmatize or shame. I mean, when you get convicted of a felony, guess what? That stuff's public. But as it relates to juveniles, we have a tiered process. And if you looked at the statute, if the district court determines that you have a low level of recidivism, a low level of that, that information only gets disclosed to law enforcement. It's only when the district court determines that your recidivism level is higher that it can get disseminated to your neighbors, 750 feet, or to schools or Boys and Girls Club or things like that. As the public, whose rights are more important in that context? The safety of the public or the confidentiality of the sex offender? Especially in relation to the way we limit that and allow juvenile sex offenders in this country or in this state to work their way off the registration process. If you remember in the Colorado case, had 2 convictions, so it was a lifetime requirement with really no reprieve. Now, I still don't think that's punishment because it's still just registration and providing information that the court already has. The only question is that going to be made public? It's a real balance of the rights.
Counsel,
yes, Your Honor.
sorry, I'm afraid you're going to run out of time, and I want to ask you about the Wyoming Constitution, because you're citing a lot of authority under the Eighth Amendment, but you've raised, or appellant has raised, a similar provision in the Wyoming Constitution. We have no law in applying that to this case. Does that not give the court quite a bit more leeway than you're allowing for?
If the court were to want to adopt the appellant's position, that is the easiest route to do that. Now, there's not a lot of understanding or historical information of how the Wyoming Supreme Court might interpret the Wyoming Constitution. However, under State versus Schneider, this court has determined that the Sex Offender Registration Act does not amount to punishment. It just didn't do it in the context of minors. But that is an escape hatch. If this court wants to adopt that position, that's a way out. It will have to forge new law, and it'll have to go in a different direction than the majority of the states and the federal courts. I mean, it's going to have to take a minority position, but it could forge new law that way.
Thank you.
That's all I have, Your Honor. Now, here's the coolest part.
No.
Except when you ask me questions, all of that was written by chatbot, AI. It's all written by AI. Thank you.
Thank you. Nice job, chatbot. Does Ms. Olson have rebuttal or? Okay. Thank you both for your arguments. I really appreciate you preparing for this and giving such great arguments, even though you didn't prepare them by yourself. Normally, I would say the court will stand in recess and we would leave, and the court would go into our conference room and have a conference about how we, at least preliminarily, would decide this case. And so we're going to do that here. I forgot to tell you that part, court. I'm going to ask you for your position. So we have the appellant here who doesn't think that MS should have to register for sex offense acts that occurred while he was a juvenile. And the state, I guess, I don't know if you're the state, who are you? Who do you represent? Saying, well, it's not punishment, so the Eighth Amendment doesn't apply, and it's fair because people need to know if there's a sex offender next door. Does that sum it up even more briefly than ChatGPT did? So, Tabitha.
I do believe it goes against the Eighth Amendment, as children should be viewed differently for crimes they committed while being a juvenile.
So, are you an affirm or a reverse?
I don't know the definitions of either.
Would you say your position again? You think it is punishment?
Yes.
And therefore, they should not be required to register? All right, so then that would be a reverse. You would be ruling in favor of Ms. Olson. Yay.
Affirm. Although I do see it as a punishment in a form, it is, I think, the higher matter is public safety of people knowing that their neighbor is a sex offender.
Okay, what about you?
I would affirm the decision on the basis that, unlike Colorado, we have the option to redress after 10 years and get their name petitioned to be off the registry. I do not see it as cruel and unusual because of that element.
I would agree. I would affirm that because in Wyoming, people have the opportunity to appeal or petition to have their name removed from the list, that it's not cruel and unusual, and it's not punishment, that it does ensure the safety of the public.
Okay, so we'll have a split decision here. I don't have to vote. We have one reverse, so she'll be writing a dissent. And one of the people in the majority will be writing the majority opinion. And then what happens in our court is, let's say you're writing the majority opinion to affirm. You'll draft the opinion. We have 90 days within which to circulate a draft opinion. So you send that out. The other justices will weigh in, and we might change our minds between conference and reviewing the opinion. Then we might look at your dissent and say, wow, that's really persuasive, and switch. It doesn't usually happen. I mean, most often we stick with our preliminary position, but not always. So that's the process. Yeah, thank you. Thank you very much, Court. I think what we're going to do now, you guys want to do a quick picture. We're going to have the justices come back up. I believe we have a few minutes for questions if you'd like to ask them. And I don't know, counsel, do you have time to stick around? They may have questions for you too. All right, we'll be right back.
No, you are welcome to ask a question. we're going to go ahead and get started here shortly. So if you have questions, I can come out into the audience, or if you want to come up and ask a question, that's fine as well. So be thinking of those and raise your hands if you want me to get to you with a question for the justices.
Is it just like any question, or would it?
Okay, this student would like to address you from the podium with her question. So,
But you know what? Don't go away, but I wanted to quickly introduce the court. And we do everything by seniority here. So this is our young guy here, Rob Jarash, the newest member of the Wyoming Supreme Court. And then to the far right, Justice Fenn. To my left, Justice Gray. To my right, Justice Boomgarden. I'm Kate Fox, the Chief Justice. What's your question?
In court, because just in my opinion, it felt like they were not very prepared. They were stuttering over their sentences, especially during the first case when it was all of you guys up front and not students. I found that oftentimes they used examples that weren't really good, such as his example of comparing a child to a pet. I felt that was very odd. And I just wanted to know, do you have to deal with that day by day?
Well, who wants to answer that?
That belongs to the chief.
Don't worry, I'll take the fall for,
well,
any answers.
I just, I'm sorry that was your impression, because actually, I can tell you that those are two very fine attorneys who were very well prepared. So what they have to do to appear before this court is, as they work through the record, so there was a trial, and the record is all the transcripts and all the exhibits and all of the things, and so they work through that record. And then they get to know the facts very well, and then they go through all of the statutes and the case law and the precedent, and they put that in the form of a brief. And so in Wyoming, you know, when you have a criminal appellant, you're going to have, there's limits to what you can appeal on and what there is. And so I think that here the issue was that the single issue I think that the defendant found that was a viable appeal was whether or not that photo was admissible. And so it was really limited to that kind of an argument, and he argued it on two bases. Number one, that it was prejudicial as inadmissible evidence, and number two, that the prosecutor did exercise misconduct in providing his reasons for doing it. And so as much as that argument could be developed, I thought both sides developed it very well. We had the advantage over the audience of the briefing, and I thought the briefing in this case was really very excellent. And so, you know, you have a 30-minute argument that you are trying to do the best you can to convince the court. The problem I think that both parties saw was prejudice. Prejudice is a hard concept to argue in these cases, and I thought to the degree that they could, both parties, you know, the state making an argument that there was no prejudice, and the defense making an argument that there was prejudice. So my view of that case was quite different than yours. I thought both sides did an excellent job.
I'd like to add that that's part of the value of us being able to come out to the communities, because this isn't television. You know, that's what so many people, their exposure to the judicial system is what they see portrayed by actors and actresses in the movies or in TV. And the fact is these are people just like all of you in the audience who have an issue, whether they're a criminal defendant or people fighting over a land contract. The attorneys are real people, and we're all real people up here, which means we're fallible and it's not always polished. And I would say, as far as good oral advocacy, and I saw that here today as well, I agree with Justice Gray, the best thing you can do, the two best things you can do is be prepared. And I believed that they were prepared based on my own preparation, and to be themselves. Because if you come up and you argue in front of us and you are not genuine in that argument, that you could be as smooth and never stutter, and all of that, but you're not going to be as credible in our eyes.
Okay, thank you. We have another question here from one of our former justices.
I just wanted to ask, do you find being on the Wyoming Supreme Court to be fulfilling and an enjoyable position to have?
Well, I think it's the best job I could possibly ever have dreamed of. But I'll ask the other justices. How about you, Justice Jarash? You've been here how long?
6 months. So far, so good. Like anything new, there are certainly significant challenges associated with it. I was a trial lawyer for 22 years, and so I was very comfortable being a trial lawyer, and it's a very new it's a very new thing for me. Everything about it, my office, the people that I work with, the kind of work that I do. But I do find it to be very intellectually stimulating. It's very challenging work. It's work that allows you to be really deliberative and thoughtful, because unlike a busy trial practice where you may have 30 or 40 cases that you're working on in any given week, we have less cases, so we're able to spend more time thinking about them. It's a very collaborative group. We all work really well together, very, very smart, hardworking people on the court, so it's always a real pleasure to work with people like that, and that includes their staffs. So yeah, I mean, for a lot of people, including me, it was a dream job, and it is a dream job, and I enjoy it very much so, although I wish I could fast forward to 2 or 3 years forward when I'm much more comfortable with what I'm doing, because that'll take away sort of some of the uncertainty that comes with a new job.
I have a question for our attorneys here. What's it like to argue in front of the Wyoming Supreme Court, and how do you prepare? Because you both have done real ones, many.
It's the most favorite part of my practice. I love it. I love coming before the court and trying to figure out a really difficult problem, and to try and advocate the best I can for my client. For me, you wouldn't notice this today, but I do really try and prepare. I mean, I read everything, I try and memorize everything, and then I do mock arguments, and it takes forever, but I do love it.
So I equally love it, and there's a big difference between the Wyoming Supreme Court and the 10th Circuit Court of Appeals. And so I do federal work, and so I'm in the 10th, and Anna's in the 10th Circuit too. And so you get 15 minutes to argue with the 10th Circuit Court of Appeals. Here you get 30 minutes to argue, and the last time I argued at the 10th Circuit Court of Appeals, I said, I'd like to make 3 points, and then that was it. They just asked me questions, one right after another, and I like the pace of the Wyoming Supreme Court better because it's just not nearly as fast, and the questions are not nearly as rapid. Not nearly as scary. I mean, they're just rapid fire questions, and I just like the pace of the Wyoming Supreme Court better. But like Anna, I really prepare for the oral argument. And so what I do is I practiced with AI today because I'm trying to get better at it, and this is a place where I can do that and not risk anything. But I put together all the materials, and I never argue out of the brief because these guys in every court I've ever been in, they read the briefs. They don't need to hear what I said in the brief. And then there's 3 arguments that you always make. There's the first argument you prepare, there's the argument you actually make, and then there's the argument you wish you made when you drive home from Cheyenne, okay? And so you want that middle argument to look the most like that argument you wish you had made. And so to do that, you have to over-prepare, 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 over-prepare. Because of the high five, and that's what we affectionately call them, you guys are familiar with the high five, of the high five, they all think differently. And so they're going to have questions and a perspective that's much different. And so like the case that Devin and the state argued this morning, the bottom line case of that is a case called State versus Wilkes. And I was the law clerk in Rock Springs when that case was tried down there. And I remember talking about those exhibits and those types of things saying, well, the photo is used to prove that the decedent is alive. Now that sounds dumb coming out my mouth. But that's the kind of things that you think about at the trial level. But you just have to be prepared because they're going to come at you and you have to be ready, and you want to be more ready than they are, and that's hard to do.
Good morning. I was wondering if you guys could give us some insight on how you make decisions. You know, when I was listening to the Eighth Amendment case, you know, in my mind, it just what felt right. And I know that the standard that you guys use is much higher. So, you know, what are some of the considerations you guys make when you have to make these really tough decisions?
Justice Fenn.
You know, we are guided by the rule of law. And so sometimes what I personally believe may be in conflict with the rule of law always prevails. And so most of the time, I agree with the rule of law, so I don't have that conflict. But, you know, the rule of law starts with our Constitution, starts with the legislation enacted statutes, and then the case law that we develop through our opinions. And that's what guides us. It's not, you know, we're just up here, I think I'm king, I think that anybody that's blonde should be poor, and anybody that has gray hair should be rich. You know, so the rule of law is what we're really guided by, and that takes its form in many ways. We are confined to the record that was created at the trial level, and so we can't just go out and do our own investigation and decide something. We're confined to the record. We're confined to certain principles of standard of review. So some things the trial judge gets a great deal of deference, or the jury gets a great deal of deference. Other things we get to decide collectively anew, called de novo. So there's lots of guidance out there as to how we decide things, and constrains us arguably to that rule of law. But all of us, I think, are just adamant that the rule of law is what is our guiding principle. And so that's what confines us and guides us in our decisions. But we all bring different experiences and perspective as well, and sometimes we don't agree. Sometimes the cases are really tough, and it's, you know, really smart people can disagree with the issue, and that's the beauty, I guess, and the challenge of our court and of our system.
Can I add to that?
Sure.
Yeah. So I actually kind of surprised Justice Fenn didn't say this, because he says this a lot in conference, but it's also guided by what's called the standard of review. So all of these cases to come to us have been heard by the trial court, and the decision has been made, obviously. And so depending on what the parties are appealing, sometimes the standard is whether or not the trial court abused its discretion. So we would have to change the ruling of the trial court, find that no reasonable person could have found the way the trial court did. Other times it's de novo, meaning that if the trial court interpreted a law or interpreted, something below a rule, that we look at that independent of the way we don't give any deference to the way the trial court did that. So there's a lot of different standards of a review that apply. So in addition to all the things that Justice Fenn said, it's also an application of the standard of review. So while it might have not been the way that I would have decided it, or even this court as a body would have decided it, if it was a discretionary ruling, oftentimes we will affirm the trial court.
I heard Justice Jerash saying that back when he was in, what were you again before, when you had to do a bunch of cases?
A trial lawyer, just a lawyer that did trials.
Yes. You had to do like 30, 40 cases a week. Is such a high workload typical?
It really just kind of depends on what kind of practice you have and what kind of lawyer you are. There's so many different kinds of lawyers, government lawyers, private practice lawyers, estate planning lawyers. But when you're a trial lawyer, someone who tries cases and appears in court to make oral arguments like Craig and Anna did today, I would say, yeah, it's pretty typical to have a fairly high workload. If you have 30 or 40 cases open at any given time as a trial lawyer in private practice, that doesn't mean you're working on all 30 or 40 cases every week. You may work on 3 or 4 or 5 cases one week and 5 different cases the next week, and you may have 15 or 20 cases that you're just waiting for a decision on. So, yeah, I think it's pretty typical to have quite a few cases, certainly when you're a trial lawyer.
First of all, I would just like to say that it was an absolute honor being in front of you guys in person today. Thank you for choosing to come to Casper. Like I said, it was just amazing to watch. But since being a Supreme Court justice is a dream job, I just want to know how you guys got to be in the positions you are today.
Sure. We all got to this position through very different routes and journeys. So I think that's the first thing you need to know. There is not some magic formula by which, if you aspire to be a judge or a justice, that you can just make that happen. There's a good deal of serendipity, but the mechanics of how it happens is a judge or justice has to retire, or there has to be a new position created by the legislature. And when that happens, there's a notification that goes out from the Supreme Court and a notice that the Wyoming State Bar sends out letting folks know there's a vacancy. And often what creates those vacancies is we have a mandatory retirement age for district court judges and Supreme Court justices of 70. So the day you turn 70, you're deemed constitutionally senile and you're out. And so that automatically creates a vacancy. And then there are 30 days that all qualified applicants, and it depends on which position you're applying for, how many years you have to have practiced, but bottom line is you have to be a licensed Wyoming attorney in good standing. Then you can submit what's called an expression of interest. It's a job application, but it is a healthy, hefty job application. You have to include all your educational background, all your work experience and prior background. You have to answer a series of questions. What's your judicial philosophy? How would you approach certain cases? You know, just really to ferret out who you are as an individual member of the bar. You have to provide writing samples. You have to provide personal character references. You have to provide the names of judges before whom you've appeared. So, you know, you have 1.5 inches, 2 inches of material, if you were to print it, that you provide to the court. At that point, and that's open for 30 days, Chief Justice Fox chairs what's called the Judicial Nominating Commission. And she is the 7th and tie-breaking member. The other 6 members, there are 3 members from the Wyoming State Bar, and they are elected by the Wyoming State Bar, their attorneys. Then there are 3 members of the Wyoming community at large, and those 3 members are appointed by the governor, and they're usually spread out around the community. around the state. They review all those applications, and they decide who of the applicants would they like to interview. They conduct interviews. If one of the members of the Judicial Nominating Commission is not from the community where the vacancy occurs, then they have a mechanism where they can get some input from a member of that community. And then they pick their top 3 candidates, and they send those 3 candidates' names to the governor of the state of Wyoming. The governor then has 30 days within which to review the materials from those 3 candidates and then make his, or maybe someday her, decision about who should be appointed to fill the vacancy. It's called the Missouri Plan, but the important thing I want you to take away is that it's a merit selection process. In some states, it's an election process. Judges are elected, and they might be elected on a nonpartisan ticket or on a partisan ticket. And in that case, they have to fundraise, and they have to campaign, and all of those kinds of things to be elected. We're really proud, and we believe it's really important in Wyoming for the independence and impartiality of the judicial branch to maintain our merit selection process. Last thing I want to say, part of that process does involve the citizens of the state of Wyoming. So it's not as though they are cut out. After you've been appointed and after you've served in your position for 1 full year, then you have to stand for retention on the ballot at the next general election. So this year is a general election year. So you will see on your Wyoming ballots lists of judges. And the vote is by the people, and it's a thumbs up or thumbs down. Again, it's not a campaign, not running against anyone else, but the public has the opportunity to do due diligence, learn about this judge or justice and how they're performing, and then exercise their right at the ballot box to vote to retain or not to retain that justice. And that's an important, or judge, that's an important part of the system as well. So thank you for asking that question.
We have one more question here.
This was really cool. I think this was a lot more conversational than I thought it was going to be when I first came here. Like, I think it's interesting how you guys interact with the different attorneys, like, in a lot more conversational of a fashion than, like, I had any experience with, which I thought that was really cool. I guess my question would be, was it more nerve-wracking for you guys doing this in front of us rather than, like, where you usually are? And, like, even though you guys do this and it's probably not as nerve-wracking as being the attorney on the other end, does it make you nervous at all, ever?
Oh, I'll answer that. People always ask me, you know, at what point did you stop being nervous? And I'm like, never. So even when I was an attorney, you know, people would ask me the same question. When you go to court and argue a motion, I'm less nervous than I was when I started, but I'm always a little nervous. And, you know, I think we should always be nervous, right? Because we want to do a great job. We want to be on. I never want to get to the point that I'm so complacent that you know, my heart rate doesn't go up a little bit when I come on the bench. And then about the interactive comment that you made, also, when I was practicing law, we had, for at least many years, the Supreme Court that didn't ask that many questions, and it was deadly boring. Even as a lawyer, to stand there and talk for 30 minutes without anybody saying anything is just awful. So it just makes it livelier and more interesting to me, and besides, we come prepared, and we have questions. We want to know certain things because we're trying to get it right. So I think the interaction is much better. I'm sure you guys agree.
Yes.
Justice Josh?
I would just add, part of your question was, is today sort of more nerve-wracking, if you're nervous, than the traditional oral arguments that you might hear in the Supreme Court? I would say maybe there's a little bit more nervousness associated with it, but I would say it's more excitement. I leave events like this, and I did when I was in private practice too, just feeling so good about the audience, the crowd, the questions that we've heard, the questions that we heard the justices ask during You Be the Judge. It's very invigorating and fulfilling for us to see sort of a younger generation of people who are interested in the same things that we are interested in. I think I speak for everyone on the court when I say we're very proud of the judiciary and we're very proud of the rule of law. And so when we have an opportunity to share it with people like you, it's really exciting and it's really fulfilling, and it really makes you feel good about what you do on a whole different level than just sort of the day-to-day work that you do.
Okay, well, thank you all for participating. Thank you for bringing your show on the road, coming to us. Thank you all for your interest and taking the opportunity to learn. So thank you to the justices.
Well, thank you. Thank you for hosting us. We love doing this, and really, this is the best venue. And thanks all for being here and asking questions. And thanks to our attorneys.
Yes.
You're welcome.